Good evening, everyone. How's everyone doing? My name is Mackenzie Wilson. Alongside me, Chris Noble from beautiful Panoka, Alberta. We are the original Landlord Shoptalk show, the show about landlording in Alberta. Chris, how are you doing tonight?
I'm doing fantastic. And yourself, Mac?
Good. It's been a busy day. I had some events today.
With that one, my friend.
What's that? Oh, I'm having a leg problem.
Max,
Chris,
you're freezing up already, bud.
Okay. Well, maybe I'll let you run with it.
Your kids must be gaming or something.
I don't think they're doing anything, but that's the problem here. Okay. Can you hear me?
Oh, well, I can hear you just fine. So, yes, we are a professional show. Well, we'd like to think we are, but things happen, right?
All right. Well, let me log into myself.
Well, yeah, we got a great show tonight. We got some eviction experts, and I know we got Robert Bonin coming on tonight, and we got Donald Gray, and we have Andrea Workington coming on tonight. These are three fantastic individuals to join us in the show with lots of great information on how to make it happen. So I lost you, Mac. So he's going to come back in. Here we go.
I'm on. Is this better now?
Yeah, we got two of you.
Oh, shoot.
There you go. Okay, I switched to my cell phone, so hoping it sounds a little bit better. I'm not sure what's going on. But yes, we have a good show. It's been a while. Move down my face.
Yeah. So tonight, I think Mac's got to check out early. You got some family commitments that he has to deal with. So,
but we got a lot of stuff to cover. We talk a little bit more about COVID, and we've got a experienced packed panel with Andrea Workington out of Central Alberta. So she's our kind of jack of all trades, realtor now, investor since 2003, and our two eviction expert, Rob Bonin and Don Gray from Edmonton Eviction Services.
Yeah, right on. So let's bring these wonderful folks in, and what's our first topic here tonight, Mac? What do we want to hit off of?
Well, let's get everyone online here, and we'll bring them on. And there you go, Chris. I thought we'd just discuss what people are seeing right now with COVID and that new restriction that came in a few weeks back here in September, and how people are dealing with it. If there's any more questions to answer about that, because I know we did talk last week on the paperwork, that basically it makes us an essential service, that we do have the right to enter your rental properties, to do inspections, to do viewings, and to do repairs and maintenance. Maybe I'll throw it out to the cast here. Don, welcome to the show. Have you seen any issues, or have you been talking to people on the group here when they're dealing with getting access to the units for COVID?
Yeah, there's been the odd person that had the odd phone call from owners and certainly old clients. What's the ruling? Why can't I get in? And their tenants are all upset, and we advise them that we are essential service, and take them to. I've got a copy of that Rob gave us there, and I think you gave us a newer one there too. So I send those to the people who want to see it actually at hand. But it's some people are using it, and the same as the first go around, there was people that are trying to use it as a method of keeping the owner out or prolonging their free rent extravaganza. So.
Yeah, absolutely. Andrea, in your neck of the woods, I know last time I talked to you, you were at 185, 190 doors. You're probably a little bit higher than that. Have you had a lot of flack or challenges dealing with the restrictions trying to get into your rentals?
Yeah, I'm up to about 240 now. So
it's been the summer. You've been busy over the summer.
Yeah, it's been busy. No, we haven't actually. It was interesting, though. We had something slightly different happen today. We went to take photos of somebody's place for advertising, and they didn't want to allow entry, not because of COVID, but because they didn't want us to take photos of their stuff, which is not expensive. But anyhow, people can be fun.
How did that pan out?
Basically, what we did is we said, well, you don't really have a choice unless you want to pay an extra month's rent, because we have the right to advertise your unit. So go ahead and take down any personal photos or something, that you feel is a prized possession, and we'll take photos, after that. So
Okay.
that's what we did.
There you go. That's funny you mentioned that. I've sort of had that issue. I had a property I bought. I had the realtor photos, so they looked amazing. And then our relationship didn't end well, so I did not renew. And then they found my listing ad, and then they complained about the photos or some personal belongings in the photos. So I went back and blurred them out. But so that's how I handle that situation. I mean, I have pictures of the house. Most of it's furniture. You can't think it's not personal stuff. So, yeah.
So Andrea, I'll put that to you as a property, put your property owner hat on and landlord hat on. What are your thoughts on having a file on each place and having some really good photos that you just remain on file rather than having to, when it's empty, and having those to show people versus having to go in to take photos every time? Because I don't think a lot of landlords practice that. I know I do, because I don't want to deal with that inconvenience.
Yeah, and generally that's what we do. But when you take on, as a property manager, when you take on new rentals, you don't really have a choice because you don't have any photos to use. But that's what we do, is every time we have a period of turnover where we can quickly snap pictures, even, if it's between the tenant moving out and the new one moving in, if you just before they move in, take a new set of photos. Just so that we're updated, especially after renovations. It certainly does overall cause less hassle. So yes, I agree with you.
No, right on. No, that's I think that's a great practice. And a lot of we don't think about those things sometimes as business owners. To unless the idea is put in, it's like common sense. You don't put your hand on the stove because you get burnt. But until you get burnt, you haven't got common sense. So hopefully these little shows and these little ideas that we put out with people is saying, hey, there's an idea. When they move out, I'll snap pictures and then we'll keep them on file. So.
Yeah, absolutely. And Mr. Rob Bond, last but not least, I know you're a busy man, so I'll give you the floor. What have you been up to over the summer, and all good things with your evictions?
It's been a pretty busy summer. I don't think it was any busier than it was 3 months ago, but it's definitely steady. I'm sure Don knows what I mean there. It's just 1 week it's quiet, and the next week suddenly you have anywhere from 5 to 7 new files, and it's a panic to get them all filed as quickly as possible. And of course, every landlord thinks that their matter needs to be heard tomorrow, and then you have to break down the 9 out of 10 of them and tell them, well, unless there's like a significant damages, or there's a threat to the neighbors or a threat to yourself, you're going to be looking at a 4 to 6 week wait.
Yeah.
One of the things I think what I've been noticing most, and probably Don as well, is we're getting more and more people that think that we're consultants, not specialists. And I know when somebody's been talking to Don, and and I'm pretty sure Don knows when someone has been talking to me, because they're asking the same questions over and over again, and they're not getting the right answers. And I think what I really wanted to put across tonight was, there's reasons behind hiring a specialist in this field. There's a reason to get proper representation. And I think that's something we should really discuss tonight. So people that are thinking about doing it on their own, that means you're doing it on your own. That doesn't mean that you're going to pick up the phone and call me or Don, and we're going to walk you through how to do what we do for a living. It's not just that simple anymore. There's liabilities. I don't want to give somebody advice and then they go and put their own personal spin on it, and then somebody's coming back yelling at us that they didn't win or they didn't get what they wanted. And there's just too many variables in a hearing now. From the hearing officer could have different political views, they could have misinterpretations, and it's on the fly. I mean, me and Don don't know what kind of really the offensive we're going to put on or defensive until we two seconds into the hearing after we find out who it is. Wouldn't you agree, Don?
Yeah, to some extent, certainly. I get a lot of people that feel that they send us the information and we should be in court in 2 days, and they get upset when we're not. So it's a real mixed bag out there. People have higher expectations than and then they get upset with the fee. So,
Yeah,
go
and
for
they
free.
call us when they tend to call us when they're hemorrhaging.
Yeah.
They I really like the fact that Chris and Kenzie on the site now are really encouraging people to go back through the site and look up the topics rather than we start up the same topic over and over and over again.
Yeah.
And I mean, I'm sure everybody here saw what I posted last week is stop looking at the quick brochures, stop looking at the consumer guides, print out the damn act and read it from front to back and do it more than once.
Well, most people don't understand all that either. They read a section and it's that's it. They read a section and they don't really understand it. So I've gotten calls from landlords who said, I'm looking at this portion of the act here, section 21. What the heck does this mean? And I'll explain it to them. I've got no problem with that.
Yeah.
And,
100%. Explaining legislation is great.
Yeah. So. Yeah, and I would encourage that too. That people do come to us with their questions, and we can help them. Not that I'm going to spend an hour.
Here's a question for you. So here's a question for you two, and Andrea. You can chime in as well. One of the questions sent to me today on a private message was, can I deduct the costs of my eviction costs out of the damage deposit?
Well, that's kind of a gray area. The court will allow.
Is that a play on words, Don?
I like.
Is that your area? Is that what you're saying, Don Gray?
Yeah, there we go. Gray area. Exactly. That's my area.
What I tend to tell people is for the costs is we'll recover as much of the cost as possible during the hearing. If it's one hearing for a termination, we're going to get the maximum cost there. If we have a second hearing for damages, we're going to recover as much of the cost there. It is a subject that's being looked at. I might have drawn a little more attention to it recently with a couple of cases where, again, we're going back to that Crystal Hallett from the Community Law Foundation there, where she's too lazy to print out a package and have it delivered in the city of Red Deer. So what she'll do is she's one of those paperwork junkies, Don, where she'll download 300 pages and send it to us, and it's up to us to print it out to go over with our clients. And I finally just said to the residential tenancy board that no, that's not going to happen anymore. I'm not absorbing any more costs for the Community Law Society. If they're going to jump into this industry, they've got to jump into it just like any other lawyer, agent, or paralegal, and they've got to bear some of their own costs. So I've refused any email service from them at this point, and I found out from several law firms that's perfectly legal. And I brought up the precedents with the residential tenancy board, and they're in agreement that if you don't want to be served by email, they've got to have a reason why they want to do that. And my offices are available 7 days a week to serve. So from now on, the Community Law Society is going to have to print out and serve a package to me because of the numerous mistakes in the past they've made with service.
So, Chris, my experience has been whenever we've gotten a court order, it's pretty much always includes our court filing fee. And certainly when I've been physically at court, sometimes we are also awarded an extra fee for our time. Occasionally it happens. Certainly when you're representing yourself, like if it was my name on the contract, not my company name, and it was my personal rental property, I tend to then, if I'm at the Court of Red Deer, they will give me a couple $100 for showing up. Now, if I'm under my Realty Experts banner, I don't get that. But if it's part of the court order and there's money from the damage deposit, so say somebody moves and the damage deposit isn't eaten up by cleaning and damages and all those other things, I apply it to whatever's left on that court order. Absolutely.
Yeah. So you got the court order to back your
absolutely
back your choice on that. The question that was given to me was odd, but a good one. The rent was paid, but they were being asked they were having to be evicted. I think the reason was they had overstayed their welcome there, so to speak, and they paid the extra month's rent, but still, basically the lease was up, I think, at the end of August, but they stayed September, and they said they weren't leaving, so then they had to do an RTDS hearing to get them out for the end of September. So the lady was saying that because I hired someone to do it, and that person charged me, just for the sake of the conversation, $500 to do that. Some of those costs are recoverable through the RTDRS, whatever they award you. But let's say there was $300 left over. I would personally, my play on that would be, and it doesn't mean what I do is right. I would consider that a form of damages, provided there was no cleaning issues, provided there was all these other things that were covered first, and then there was maybe $250 left over of a damage deposit. I would keep it as costs, damages, to have hired someone to do that.
Absolutely.
What are your thoughts?
Oh yeah,
It's
100%,
like
Chris.
Administration fee, right?
Yeah,
And
100%.
so in our lease agreements, it says if we have to deliver a 14-day notice, we're charging you $50 administration fee for that, right? And so it's written right in the lease agreement. You agreed to it. And so if we're posting that piece of paper, it's going on your rent roll as a charge. So
Yeah, that would be a fee, and the fees are allowed. In regards to the extra charges, you're talking about $300. You certainly, I advise, when I get that question quite often from landlords. I advise them that certainly if there's money left over, they could apply that. But now, to be wary that if the tenant decides to sue for their remaining part of their security deposit, then the judge may disallow them that portion of the fee. Because as far as the RTDRS is concerned, they've given you money for that, whether if it's by yourself, it's $75. If it's for Rob or I, it's $225. So, if we charged $500, for example, then, there's $375 there that, if they wanted to charge it, to go right ahead, but be wary that if they got countersued or sued for the security deposit, the judge may disallow that.
Yeah, I think part of the thing I do as well is whenever somebody says, "Can I charge this? Can I charge that?" And I said, "You can charge anything you want.
Mm-hmm.
Just be prepared to argue it in court.
Yeah.
You have to be able to sustain your argument with some kind of evidence. So, I mean, you can make any argument you want with the RTDRS or the courthouse, but you better have evidence to back it up. Like Andrea was saying, where she's labeled things as administration fees, she can go back to release and say, well, I did charge that $50 because they initialed right beside that. And again, most judges, most hearing officers may allow it, but you might run into that one hearing officer that just goes, "Meh, I'm not going to allow it. Doesn't matter what your lease says because it's not in the act." It all depends on how you present your argument.
So let's open this up. You guys bring a really, really good point. What is the scope if it's well written? And you've already painted the context there, Rob, that some things can be charged if it's documented. And Angie, you kind of brought this topic up, so thank you for that. What are the different things we can cover our butts and charge for our time? So we've got a 14-day notice. What else would fit into this envelope of chargeable items?
I also have administration fees. I don't charge late fees on my leases. I call them administration fees. And how I explain it is rent's due on or before the 1st of each month, just like it says in the act. 5 o'clock rolls around the 1st. If I've got to pick up the phone call or direct a staff member, that's a $25 charge. If I have to phone, because it's not our responsibility. The next day rolls around. If I have to make 2 more phone calls, that's $25 a phone call. If I have to deliver notices, like Andrew, that's $50 a call. I just have a list of them in the lease of what our administration charges can be and how we're going to argue to recoup those costs. So as long as you've got a reasonable, me and Don love that word, a reasonable argument. I mean, if you say, well, I'm charging you $500 to deliver a notice. Well, yeah, the hearing officers and the judges are going to laugh you out of the room. So everything that you argue has to be reasonable.
Awesome. I've never even thought of this because I just, standard quote, I got a late fee, here you go. And now, you're accounting for the time when you have to deal with unexpected things that you shouldn't be dealing with if people are following the expectations in your lease. So interesting. I'm going to go back and rework some stuff here.
If I may,
go ahead, Don.
Yeah, don't charge a late fee, you charge an administration fee. Administration
That's
fees are allowed. I had a client just a while ago. That's what they put it in as administration fees. There wasn't a beep from the adjudicator, and they went through. But if it said late fees, as most people have, then they're disallowed because the court doesn't collect late fees. You can charge them; it's legal, but the court doesn't collect them. They see it as punitive damages.
Yeah. I actually tell my
phenomenal.
clients that I won't even make the argument for them. I said, no, we're taking it out.
Yeah, I do too. Yeah.
Andrea, how about yourself here with these admin fees? What other circumstances do you try to protect yourself with?
Yeah, so like I mentioned before, we have the $50 admin fee for having to serve eviction notices. Other than that, we don't have any other admin fees other than the late payment, which we call an admin fee for having to, receive money for money paid after the first.
Yeah.
So yeah, that's our basics of it, and yeah.
Cool. All right. I'm going to segue this conversation. We got our first live question in from, and I'm sorry if I butcher your name. I got the Facebook feed open. I'm being proactive like Mr. Chris Noble here. Baljit, Baljit. I'm sorry if I'm not pronouncing it correctly. So she was the one had the first question in the screen, but she's asking here, is there, I'm going to just paraphrase, is there a way to add a missing tenant to a RTDRS order that's already been granted?
I actually just did this yesterday.
All right.
The original application had a boyfriend and girlfriend, and the arbitrator just made an error. He only put the girlfriend's name, so I quickly made a phone call. I just needed it amended. Sometimes they ask for it in writing, depending on what the amendment was, and they added the name and sent it back. Most times if it's an error, they'll just amend it and send you a new one. But if it's your error, then you usually have to make some kind of application online to show the reason why you want that added.
So if it's reasonable, as this is the key word that we're using, you can make amendments to an existing order.
Yes.
Great.
If it's missed by the court, but if it's missed by you, as Rob was saying, then a lot of times you have to redo the hearing. I've run into this. It's been quite a few years since I've had that, but we had to redo the hearing because there was one other person that should have been on there.
Yeah, and you can always ask for it during the hearing. I mean, I had an applicant, they filed themselves, and there was quite a few errors on it. So I always refer to it as housekeeping right off the bat, saying, I have a little bit of housekeeping to deal with right before the hearing gets started, and saying, I noticed the lease says this person. We also now are aware that there's another person living there. So we'd like it to be amended to any and all other occupants to be evicted as well. Yeah. And I mean, and again, the tenant can make the argument back that they don't want that, but they have to have a good reason why that reasonable request has to be denied.
So she's giving you feedback. So Baljit wrote, so it was her error. They told me to put aside original claim and do a brand new one.
Yep. Like Don said, she made the error, or he or she made the error. They're going to have the order set aside and reheard. So they could be waiting another 4 to 6 weeks to get that order reheard.
Yeah.
Shoot, that's unfortunate. And then she's just adding in here saying that it was a very rude conversation with the RTDRS personnel. So,
and this is another good reason why professional representation is so important.
So I like to use that as our segue.
We'll pick the picture here is depending who you guys get in the court as your arbitrator or your hearing officer. I know you gentlemen. Sorry, I gotta look at the right camera here. I know you guys are particular how you word your cases, specifically to who's hearing your case, and I know that plays a big important part because depending on someone's tendencies and all that, you'll approach the case a bit differently for the best outcome.
Yeah, it's not so much how we word it. We have to word it for all of them because we don't know who we're getting. Sometimes we can guess when we look on the, which room it is, but sometimes that changes as well. But it's how we present it is a little bit different for different ones.
Thank you.
Yeah.
Yeah. I should correct myself. While doing it live in person, it is the wording around your conversation, not the wording of the actual the documentation. So.
Well, and like Don says too, I mean, you may have an arbitrator that gets along great with you.
Mhm.
And you might have a personality conflict. I think me and Don have talked about this. One, I'm not going to bring names into it. We've butted heads, and yet Don gets along with her great.
Yeah.
It's a personality conflict. So now, and you can even have somebody that's you get along with, and they're having a bad day. Maybe they've had 6 hearings that have just been dragging out because of shitty landlords or shitty tenants or whatever you want to call it. And they get to you. And if I hear that the arbitrator's having a bad day, I let them talk. I let them walk the walk. I let them control the hearing. And then I pick my moment to start talking, because that person that was just saying that comment, they were really rude. They don't know what just happened in that arbitrator's hearing before. They might have had a 4-hour hearing that should have been 20 minutes long. And maybe it was the hearing officer that let the tenant or landlord go on too long. So now in this hearing, they're like, yeah, that's not going to happen. And all of a sudden they get a little snippy of somebody that's not used to protocol and respect. And yeah, they'll be rude to you.
I had one this morning. The tenant, I think he had some mental issues, but anyway, he got louder and louder and louder, and he ended up, he was cut off twice by the arbitrator. And then they phoned back and asked, as he calmed down a little. And anyway, finally, he just screamed at her and called her a few names and then hung up on her. So I think he probably felt good about himself after that. Didn't go his way, though.
Well, I even had one here last week that, and I've been trying to do it at the end, that there's an arbitrator that I've been building some bridges with, because we had a bit of a personality conflict to begin with. But at the end of the hearing, she's evicting a lady in her 60s from a place she's been in 3-4 years because of guest mismanagement and family are drug addicts in the building. And at the very end of it, she's upset. The arbitrator's upset because she's having to give this woman a three-day eviction. And so I said, I put the whole thing on mute so I could talk to the owner. And I said, hey, why don't we extend this to 5 days to give her a few more days? And in the meantime, I gave resources like dial 211 to get income assistance. Talk to the Braden group. They'll help you relocate and even rent a U-Haul. I just happen to know a guy that owns a dealership that we can get a U-Haul for you and help you out. And all of a sudden, this arbitrator was just like, wow, that's really nice of you, Rob. And she's all confused. And it just threw her for a loop that I'm bending over backwards. And I was like, well, not everybody's heartless. They just want their property back in good condition.
Yeah. No, that goes a long ways.
So, Max, if I could jump in, one of the things I'd like to segue, because what we're talking about is about proper representation in court. And Andrea, you have a lot of experience in law enforcement previous to what you do now, so you're comfortable going into the courts. But we have a lot of members in our group that don't have a lot of experience presenting, never mind court, but just presenting, standing up in front of somebody and talking. And just to stand up in front of somebody and talk isn't always the easiest thing to do, but then you have to know something about facts, something about law, something about what you can ask for, what you can't ask for. So where I'm going with this is that both Rob and Don do this for a living. And you think, oh man, it's going to cost me $800 to have these guys do this. But you charge $1,800 rent or $1,500 rent, and these people are in there into the second month before you're even doing something. So if you do some simple math on this, are you going to let them stay for another month and be out $1,500? Or are you going to invest in yourself and invest in your property and pay an $800 fee or a $500 fee or whatever it is to get this work done? And I want people to really, when you're watching the show now or later, really think about what the cost is here to you and what the value is for what you're getting for your money. And I'm not trying to sell their services. I'm trying to get you to look at this from a very practical point of view. When we have Andrea here, because of her background, she can represent herself and go in there like a rock and slam dunk this thing. However, we do have other people on here who are struggling and they're continuously asking questions. And even though you hire maybe Rob or Don, you can still be at the hearing. You can still hear how things go and you can still learn. Mm-hmm. So I'm going to put that out to the three of you to hash out here now. Start with you, Andrea, then over to Rob and up to Don. But I want to talk about the value of what you offer because of your experience. And the last thing I'll say is you can always install the carpet or the flooring. And what's it going to look like when it's done? Or do you hire the guy to put the flooring in? So over to you, Andrea.
Yeah, I think really the main thing is as much as people may feel that court can be a scary place, you just have to think about it as having an honest conversation. And so be prepared, take some notes, make sure you got all your documents with you, review them before the call. And especially on the RTDRS side, it really is like a conversation. And so, try to have like a time frame, right? So this is when the person moved in. So you're just going, very factually. You got to take all the emotion out of it. You really do. Because when you get emotional, you tend to forget what you're saying, or you don't effectively get your point across. And I think it's really important, like Robert talked about earlier, is, we're all human and we can be, kind souls, but we need to be factual in what we're doing. And to give you an idea, occasionally as a landlord, you may end up like I did at criminal court as a witness. And so that's even just, for most people, that's even just scarier, right? Because now you're on the criminal side and you have a summons to appear to court. So really dealing with landlord-tenant issues is just tell your story, but tell it in a very clear and concise manner and just the facts.
Yeah, no, I agree with
so
her.
chronologically presented.
Mm-hmm.
Yeah. A lot of times when they're doing it on their own, but like Andrea said, you can't take it personal. It's a business, and having an agent to represent you when Andrea goes out there and let's say she's a first-time landlord, she's a first-time hearing, and she gives her story, and halfway through that hearing, let's just say I'm a female tenant, and I say to Andrea, I say to the hearing, well, I found Andrea's husband very inappropriate when he walked in on me on the shower. And of course, Andrea's reaction is going to be like, what? But it happens. You have to be ready and prepared that tenants will go in there and lie flat out. And that's where things turn really sour. Because I've had times where I see the landlord about to react and I mute real fast. And I say, it's okay. Let this person dig a hole. Let them dig a hole, because at the end of the day, it's hearsay. And I'll let a person bury themselves. And a lot of times too, when we start throwing facts out and we present them in such a way, myself or Don or even Andrea included, you present them in such a way that they're irrefutable. You can't even argue it. I'll even throw in facts that, okay, landlord screwed up. They made a mistake. Mm-hmm. My opening statement, I make sure we take credit for the mistake and how I've advised them in the future not to do that kind of thing. And we realize that we're not going to be able to get as much money, or we might have to wait another week. We own that mistake as a landlord and take credit for it. And then the tenant standing there in the hearing going, well, but my landlord was bad. They didn't give me 24 hours notice. And the hearing officer is doing the old, I know, Mr. Bonin brought that up and they've apologized to the courts for that. And they're prepared if there's any consequences here. So I always treat my clients when they come to see me, whether they be a tenant or a landlord, I need to know every dirty little thing that happened so I don't get surprised in a hearing. And I don't care how bad it was or how badly you screwed up. We can make that argument for you, or we can do some corrective measures, or we can make some adjustments to the dollar value if it's a claim, because I've seen claims go right sideways over a fact that gets brought up at the last second. When you agree,
before we jump over to you, Don,
the thing is,
jump to you, Don, I just like to say that's critical in what I've been trying to lay out to everybody, is that having proper representation. Now, where a landlord would think, well, maybe if I don't say anything, then they won't know. And when it starts to come out, you have to scramble. Where Rob just threw himself on the blade and his client on the blade and said, this is what we've done, and this is what we're dealing with. And they go, okay, great, thanks. And the credibility that you build and the honesty, and that's where the value comes in having somebody who knows what they're doing represent you and goes back and do the math. Is it worth risking everything? and getting a partial judgment or no judgment, or paying a little bit of money and getting those people out of your place. Don, over to
Well,
you.
and just to add one more thing on that, like me and Don were discussing, there's 17 arbitrators in Alberta. Is there not, Don?
I believe so. Yeah.
Yeah. So, I mean, there might be some stuff that I'm like, you know what? I know this arbitrator. We don't need to disclose that. They're not going to care. Or, oh, we need to disclose that. This arbitrator will hang us out to dry if we don't disclose that fact. So a lot of times the game plan doesn't happen until 2 seconds into the hearing. The game plan could be this, and suddenly it's like, whoop, we got the worst person possible for this. We're going this direction now.
Yeah.
But it's still the same facts. It's still the same evidence. It's just presented in a different way. And that's just experience.
Yeah, absolutely. And we have a reputation with these 17 people developed over time. And once they know that what we're going to present is the truth as we know it, there's no surprises come out. We're telling the truth, and we do that every time. And we work with the court when it's time to work with the court. When there is a situation where we should have a little bit of leniency, and we work with the court on that. When we present a really tough face, but when the end comes up, we actually do what is fair. When I have a client that starts on me on the price, I ask him, how deep is your pockets? How long are you able to handle loss? Or can you handle 3 or 4 or 5 or 6 months of no rent? If you want to move ahead now, we can cut the bleeding. That's what we got to do. We got to cut the bleeding and move forward. And that's usually the argument that wins it over. And they understand that, their pocket isn't that deep. I mean, there's some there with some pretty deep pockets, but they don't want to spend it on that. And that's for sure.
Let's go to this question here from it says, so how much can I charge for admin now filing 3 times, serving documents, printing copies, mailing, serving garnishes, which, by the way, company kept my $25 admin check I sent, with registering mails, 3 chips to the core that cost me a total of 12 hours. So
now this person here is, I'm assuming they're doing it themselves. So a lot of that stuff they're not even going to consider, because like Andrea said before, if you're putting it under your own name, they just say that's part of landlording. And again, that 225 is a maximum number each hearing. It doesn't matter if you had to print out 9,000 pages. At the end of the day, that's their maximum, and you need to make one hell of an argument to go above that cap. And just because, and again, I see everything this person has written in there. A lot of that stuff I wouldn't even have done. It probably would have taken me half that time. Again, said that we've had filing 3 times. Well, if someone would have hired possibly Don or myself or Andrea, it would have been filed 1 time, and there wouldn't have been any problems. Any of that would have followed up behind it. So, I mean, that person's asking for all these costs, but they're inexperienced, so they're just not going to get it from a hearing officer. I just don't see it happening.
What I see here, what I see here is that they've already got the court order, and they're trying to collect. I tell my clients that it's probably easier to use a collection agency. There are several out there that won't charge unless they collect. So that would save them all that time and all that effort and all those costs.
Yep, 100%. And the headache. Like, what's your time worth?
That's right.
Okay, so these fees that are being mentioned in this question are talking about garnishee fees and serving documents. Some of these fees are no longer, these are outside of the court awarded judgment. So where this goes to is you're going to take these receipts and you're going to file them back with the court so that they can add it on to the garnishee that you'll continue to do. So you got a 2-part question here. One part is what you're going to be asking for at the hearing. The second part about filing the $25 admin check, all those things you're going to keep for receipts, and you're going to file that back at the court to prove that even though you have a $2,000 judgment and you collected $1,500, there's still now $400 in administrative type expenses. So you add that $400 back in, and you can still go back after them for $900 more. So there's that's a two-part question. I don't know if you're realizing that, but the user's asking. So one's inside the court for your fees like Don charges and Rob charges, and then there's the fees outside the administration end of it for you to do your garnishes.
Yeah.
I did see something similar to this where it wasn't an RTDRS matter. What it was is a guy was suing for damages to a plane that he had repaired, and I went just to watch it, and he went through the collections process, and I believe it was in front of Judge Hunter, if I'm not wrong here, and Judge Hunter basically said, you know, those are all part and part of collection costs. He says there's nothing the courts can do to enforce that. He says you can hire a collection agency or know what you're doing. I mean, at the end of the day, it's collections. And the courts aren't going to award you above and beyond that, because people would be going back to court again, the same thing, and again for the same thing. It's like they draw a line in the sand. They're just going to say no.
Okay. Andrea, we'll go over to you. Let's talk about the collection end of it. What's your experience with our new partner, the Landlord Credit Bureau? Tell us about that.
Yes, so we joined the Landlord Credit Bureau, I think it was earlier this year, and we have collected some funds back, which is great. What I love about it is to continue to email these people, and you know, it produces results. So especially when people want to go buy a house or buy something big, they need to pay us up, and we've entered into payment plans with people, so it's been fantastic.
Tell us about give us a little example of immediate success. I think you got one of those stories.
I did. So within probably a few hours of somebody getting an email, it was only $100 worth, but they paid it.
Nice.
$100 more you have now.
Yeah, exactly.
Well, and I just had one recently too. That little old lady I was talking about, she ended up owing $1,300 in damages. And it never hurts to make a phone call. Instead of just refiling, make a phone call, see where they stand, get a payment plan going. And I had a 15-minute conversation. First, I opened up with, I hope you're in a safer place. Did you find a good home? Yep. Have you got out of that toxic situation that your daughter put you in with drugs? Oh, 100%. I'm on the 9th floor of a building. I'm in great shape. Great. Let's talk about $1,300 in damages to the property. And she was like, oh, yeah, I don't know what to do. And I'm like, well, would you like to figure out a payment plan? Because I don't want to drag you back into court, and I don't want to drag you through that process again and have you cry again and get you all upset and then have to pay more costs on top of that. And she goes, what do you suggest? And I'm like, well, what can you afford a month? And we ended up working out that she's going to pay $150 a month until it's paid up over, I think it was like 9.5 months. And the landlord was flabbergasted. She was just like, she did what? I'm like, yeah, you just put it to him in plain English. Like Andrea was saying, have an honest conversation. And sometimes people see the light.
Yeah, that's great. That's great. So, Rob, you've made some headway with changes with the RTDRS and about serving documents. Talk about that for a minute or two. Tell us about proper service versus what people maybe shouldn't be doing.
Well, Don probably noticed, and Andrea probably, if they filed anything in the last couple of months, they saw probably that it's now a declaration of service. Eh, Don?
That's right.
They didn't give us it. I had worked on that for about a month, saying how ridiculous it was during COVID trying to get someone to notarize or a commissioner of oaths. And I says, and you guys are doing a declaration verbally in the hearings now. Why not just make it a declaration of service? And I had the ear of 3 or 4 hearing officers after the hearings. Hey, can you touch base and see what you think? And then nobody even gave me a heads up. And then all of a sudden I got a new package and there's the declaration of service. And one of the things they did include on that portion of it, as Don probably saw and Andrea, is it says right on there, email of service is permissible as long as you've made contact with the party before and you have consent. Problem is it hasn't really been scrutinized up until a staff meeting last Friday at 8:30 a.m. And I think we're going to see some changes again because of what happened with that little unscrupulous Crystal Hallett from the Law Society. Is now they're going to want to see the tracking software. They're just not going to take a declaration that you did it or that you sent in an email saying, well, here, I sent it to Don. Yeah, where's the tracking software that said Don read it?
Yeah.
And Don has, And you'll actually have, it sounds like, Don, you're going to actually have the right to say no to email service, whether they have it or not, because if you have an office or a postal box, they could send that package to you. There's no reason for that you have to take the time to print everything out.
Yeah, I got a big printer so that I could do that.
Yeah, but again, why would you want to pass that cost on or absorb that cost yourself? I mean, when you get some of these people, they'll have 500 pages of evidence, and it's ridiculous. Or we try and summarize everything in 20 to 25 pages at most.
Yeah.
So I mean, I think we're gonna see some changes this week. I've made a couple inquiries, and there's something going on with it. I don't know what it is, but they're going to streamline it again, the service part of it.
Great. So we're getting towards the end of the shift here, so we're going to start going a little bit of a roundtable here. So, Rob, give us some things that you would like to see landlords practice a little more better practice in their business.
I think the one that me and Don probably see a lot is, what do you mean you didn't do a move-in report? You have to, again, what I said last week, print out the act. And yes, it's a long, drawn-out process, but I mean, you're making an investment. I don't know, Andrea, would 300,000 be an acceptable number for your first investment? You're making an investment of $300,000, and you don't want to take a half a day to read the act front to back. Most of these people that are buying are mature people. They'll go out and read a novel in 2 days, but they don't want to read the act from front to back. And Don's right. It's difficult to understand, but it's like reading a book the first time and then putting it aside and reading it again a week later. Each time you read it, you're going to get a little more out of it. So it should be something that you're reading again and again and again and implying it on each situation. So landlords, I think, need to take some personal responsibility. And I mean, going into a hearing saying, well, I didn't know that. Well, if you've got a $300,000 to $500,000 investment, you better know that. So it's time, that it's way past due. I think it's coming that the judges and the hearing officers are going to get tired of ignorance. Is not an excuse. This is a business, and you need to treat it as such.
Mm-hmm. Andrea, what's a good best practice from your angle?
Yeah, I think that it's super important to have all your paperwork and to know what it is your rights are. So I can't stress that heavily enough. Otherwise, people walk all over you. And, it's interesting because occasionally in the chat box, we see things about, people tenants damaging things and not being held to account, and, just people just not understanding what the difference is between normal wear and tear and what's damage. So, some of it comes from experience over time for sure, but I would highly recommend that people be active, be proactive, figure out, if your weak spot is falling for people who have a story, then do not rent to people who have a story. Because we meet these people that are like, oh, well, I'm not a very good landlord because people tell me a story and I feel bad. So that's when the emotion comes into it. I look at, okay, if this person has $6,000 of income and my rent is, $2,000 or less, this person is probably going to be able to pay my rent just fine, depending on what their other payments are. Let's just look at this person in a mathematical formula. A, are they employed? Yay. B, do they present well? Yay. The people that come in when you're doing a viewing and they're looking under every cupboard and testing every tap. I mean, these people are like, I don't want these people. They're going to find something wrong wherever they go. Next, not interested. They're too much
high maintenance.
Yes.
Because we got a question pop up here from the Landlord Credit Bureau from Kelly. So I'll just put this up here where she says, Landlord Credit Bureau works as past tenants agreed via email to pay for broken lease costs. And I followed up via email for a few months, then registered with Landlord Credit Bureau. Within 3 weeks, a tenant called me to let me know he will be making the. Can you imagine? I think Gord Heisler is another member of our group here, and Andrea, we all know him quite well, and he's a pretty big pretty big on the rental front as a businessman, and he's registered with it. And he got some pretty big coin in a very short time just by, and again, the landlord credit bureau sends an email out and says, hey, this is what's going to happen to your credit if you don't want to pay. And all of a sudden, people started making deals with him, and he got a whole bunch of bad debt come back in. And anybody who knows of a accounting process, once you've written something off, that comes off your bottom line. However, the following year, when you get it back, that's pure profit for you. Because it's money coming in you didn't expect. So the next year you have, it's a pure profit because you've already written it off. So if you understand that concept. So, Don, it's up to you, my friend. What are your best practices thoughts? A little bit different from these other two.
Well, as Rob has said, people who have, or Andrea, I can't remember who has said it, but anyway, not having move-in reports, not having leases, a handshake. We're starting in a hole and we got to dig our way out. And I mean, it's all doable. When talking about knowing the act, I have on my desk here 2 binders. There's half of it, and the other half is over here. And then I got a couple extra ones. And I look at these every once in a while. If somebody's got a question or I'm wondering about something, and I'll go and make sure that what my thought is correct. And that's why I have them. I have them handy. And so that's what I suggest, even if it's just the Residential Tenancy Act, to have that handy, and don't be afraid to look at it. Don't be afraid to give somebody a call to say, what the heck does this mean? We're more than willing to help with that. That's probably the things that I see that could be changed. Owners would treat this as a business, not it's a friend or it's a friend's friend or just somebody that needs a place. Well, why do all that paperwork? Is just too much work. You need to do it. You need to treat it as a business, even if it's just one unit, not even an up and down, just one unit, to keep everything the way it's supposed to be, so that if you get yourself in a hole, you have a way of getting out of it in a reasonably reasonable way that doesn't cause you as much stress. Right.
And that's the big thing. You want to run a business with the least amount of stress and the most amount of profit that you can. And doing proper background checks. So you're going to use perhaps single key, or go through the Landlord Credit Bureau if you're a member there. We have had people on here say that what's the best way to do a collection? Every single time I'll write on there and tag the Landlord Credit Bureau.
100%.
That is the most cost-effective way for. Don't quote me on it. I think it's $40 to send your information in them about your judgment that you have. And then it's there for something like 10 years. Andrea, I haven't had to register anything, but is it like 10 years or something like that?
Yeah.
Mm-hmm. Yeah, and it's worth the peace of mind. It really is. Yeah. I couldn't imagine chasing after someone and stressing myself out. And their fees are a write-off anyway. So anything they take off the top, you get to write it off again.
Yeah. So it goes to your bottom, it goes back to your business. It's a cost of doing business. And you should, have in the bank 2 months worth of mortgage payments. If you're doing
at least, I go 3.
Budgeting correctly. I know some of us on here, you go 3. But what? I know some people, and I appreciate it. Some of us, not myself included, but are landlords by default, and accidental landlords, we call it. And I appreciate that. But somehow, some way, try to build that account up for these recs. Do your checks. These are my advice. Do your checks. Right on our page. Does anybody know John Smith, if they had any problems with him? Well, I'll tell you, there's days our page just lights up.
Lights up like
no,
Christmas.
Absolutely not. Yeah.
I would like to add one thing, Chris.
Yeah.
Yeah. Somebody asked me the other day why they should, they private messaged me and it says, well, why should we hire you or Don or any of these people in this industry? You guys just building and capping. And I said, I gave it a little bit of thought. And I think I mentioned this one to you, Chris. And I said, the people come and see us when the shit's hit the fan.
Yeah.
They don't come us when things can be walked through, or maybe we can find a resolution. They come and see us when they're hemorrhaging. And I said, okay, your appendix has burst. Do you go to the hospital and hire the professional to get your appendix out to save your life? Or do you phone the doctor and say, hey, can you walk me through the surgery and how to take this appendix out? You know, it's really simple math right there. As Andrea said, treat it like a business. This is not a learning curve. You do not want to, oh, well, gee, I guess like Don was saying, do you want them out right away, or do you want them having to pay not paying another 2 months rent that you're gonna have to fight for later? There's all kinds of things we can do in a hearing to change the end result. We could put conditions in it that if they don't do something, that suddenly it could be a week-long eviction. But these are things that only people in the industry know about. You know, it's last-minute things.
Casa Capital is one of our members on our page, and one thing they practice is they will go ahead, they'll spend the $75, and they'll get, they know something's coming down the pipe. They can see it, they'll go spend the $75, and they'll have that little hearing ready, set in their pocket. They'll try to negotiate with the person. They'll try to get things in order. If they don't, you know what? Because we're looking at anywhere from 6 to 8 weeks out sometimes for a hearing. It's getting better now because people are coming back from holidays. But when you're waiting 6 weeks for a hearing, that's taking you into another month. And then you may get a week, maybe 2 weeks to get them out. So when they're already practicing getting the hearing in order, keeping that little piece of paper to serve them in their back pocket, the person decides then they're becoming difficult. Boom, they got it. They serve them. They go, "What's this?" Well, hearing's in a week. Here's your copy. Then when they get into court, they don't make themselves look like the bad guy. They make themselves look like, I've been trying to work with them, and here's what I've done for the last 4 weeks up until today. And now what we'd like to do is if they say they'll pay, which some tenants say, well, I'd like to arrange payment program. So they do, but what they do is they get the order in their favor, subject to, or a conditional order, wherein that they don't pay, then the eviction, right, Rob? The eviction.
We'll have a condition right in there that says if they don't abide by these certain rules or conditions that we placed in the order, that instead of getting them out in 4 weeks, suddenly it can happen in a day or 5 days or a week, depending on the severity of it.
Yeah. So people who are versed in the system. So the people that are versed in the system the way it works, you wonder why you pay Rob and Don. It's because they know these things, and Andrea knows these things, and that's why you're paying. And now you've learned it, but you're thinking, okay, well, that's really cool. What did they talk about on the show? How can I do that? And then you end up phoning and say, well, how am I going to do this? Well, you know what? There comes a point where our experts here can give you only so much advice, but at some point in time, you've got to hand it over to them to do. So them a little bit because our plugging them is a better word, because they're good at what they do, and you need to be good at what you do and in your business, and that is running that thing, getting good tenants in, taking advantage of the partnerships we've created on this page, and running your business. But when it goes sideways, look to these people to help you, because that's what they're here for. We've hit the 8 o'clock mark, guys, and we tried to keep it for an hour. We'll just do a very fast final thoughts, and then we're going to then we'll conclude, and we'll have a little behind stage chat with the 3 of us, 4 of us. Andrea, over to you. Final thoughts.
Treat it like a business.
That's simple. Robert?
Keep emotions out of it.
That's right. And Dawn, up to you.
Don't be afraid to call us.
That's right. Call us. And Dawn's with the Edmonton Eviction Services. Rob, I don't know what your branding's about. I know you got a lone wolf thing going on there, but but look for Rob Bow on the page. And Andrea, I think you'll pick up one now and then, but you are busy, but at least you'll direct somebody to where you can get to, right? Right. So Andrea's got herself muted, so. All right, folks, thank you very much. That's again, Alberta Landlord Community, our second show of the year. We'll be going throughout the winter and into the spring again. So every week, if you want us to talk about something, send Mac or I a message, and we'll throw her in, or we'll create a show out of it. We're going to try to bring you some different guests throughout the year again. And here we go with season 2. Thank you very much for joining me, everybody. Have a good night.